Recently, the MetaBirkins case finally came down to a final decision. This is one of the first and biggest NFT cases out there related to trademarks and intellectual property. So it's going to start setting the precedent, and it's quite important. If anyone is into NFT, you've probably heard of it. If you're into fashion, you've heard of Birkin bags, and MetaBirkins tried to claim that they were creating an artistic expression off of that, and therefore they were not infringing. Um, Interesting here is that this actually went all the way to the jury, and the jury found that it was an infringement. They awarded Hermes $110,000 for trademark infringement and $23,000 for cyber squatting, which is related to trademark infringement. Um, Basically, probably here because of they have this Birkins in their domain name. Birkin bag was a well-known, famous trademark before they ever bought and set up this domain. So they were able to get them under cyber squatting because they're trying to play off of Hermes's goodwill with the Birkin brand. A few things to note prior to going to the jury. Both sides asked the judge for a summary judgment. And what that is saying, hey, judge, look at all the evidence, look at the legal arguments. No jury could possibly find in favor of the other side. You should just award us this win, whether it's a dismissal, which is what Rothschild sought, who's the artist that created the MetaBirkins, or Hermes saying, look, this guy is so infringing on us. He has no rights. There's no defenses here. You should award it to us. But the judge didn't feel either side was proved the case fully and let it go to the jury. And the jury said basically that it was an infringement. In his opinion on the summary judgment, the judge wrote, a reasonable juror can conclude that Rothschild's claim that he viewed MetaBirkins as a largely artistic endeavor is a fabrication. So sounds like he kind of sided a little bit with MetaBirkin on it, because his arguments are all just based on that this is art and it's a form of artistic expression and could be protected as such. Few things to note here is that the filing for anything related to NFTs by companies is on the rise. As you see, I just did a search for a non-fungible token. There's over 10,000 applications. NFTs only a couple of years ago really started out big. And more important to note is when you look here, I did a search then for Hermes, and they have a few. They have one for Birkin that's supposed to cover, NFTs, and then they have one for Kelly, which I guess maybe is one of their other big brands, and then they have just for Hermes itself. Another company that's been heavily filing and seeking to protect, they're actually in the process of another lawsuit for an NFT, is Nike. So it looks like they have 8, according to this search, 8 trademarks related to NFTs, for their swoosh, dot swoosh. I believe they have dot swoosh with the dot written out. And then some of the other ones, I don't know, why they have for these ones, but this is, Space Pod, Loot, DARTX. I don't know all of Nike brands that well, but there is another case coming down that's related to Nike and a company that's creating NFTs of their shoes, and the company actually stores the shoes for you. So that's a little different than the Birkin bags, and we'll see how that one plays out, because there is an actual physical shoe that goes to the NFT in that case, and owning the NFT is kind of proof that you own the shoes, but I believe the shoes are just stored somewhere for you. So we'll look into that one in another video, And if you like these, please follow along. If you have any questions, put them in the comments below and we'll respond. Thanks for watching.